Judge Dickinson is saying that he doesn't have it.
I don't see the package in my email.
That's Judge Dickinson. So, you'll have the packet in my email either. So, all of the members who participated in the meetings, they're saying that they need it. So, we'll get that email to y'all. We're getting that email to you right now. For the members who are present, you should have a copy. And in that particular packet, you should see a copy of it. You should have a copy. Could you please mute? Thank you. Got it. Thank you. I have to have a little help doing this sometimes. We have a copy of the minutes from the last meeting that are in the packet and from the August 15th, 2023 task force meeting. And I'm going to do just like we did the last time, since the members who are participating via Zoom have not received the packet. They probably haven't had a chance to review the minutes. So we'll just pass this until the end of our meeting to give everyone a chance to peruse the minutes. And we're delighted to have subcommittee number 2, who is going to be presenting today. That's going to be Judge Joseph Kilgore and his team. And so, without further ado, I'm going to recognize Judge Joseph Kilgore for the presentation for subcommittee number 2.
All right. Thank you so much, Madam Chairman. We're glad to be here today. And I just want to reintroduce my team just very briefly. And at the end of our last Zoom meeting, we all agreed that this was it's a great team, and it's a great team to work with. It's been very productive, and I've just been honored to work with these ladies. And to my left is Jennifer Morgan, the Parent Defense Program Manager at the Office of State Public Defender. It's just been an amazing resource for us. And
Judge Kilgore, could you pull your mic a little bit closer to you? And I'm not sure if the mic is on.
Okay. Is that better? Is that a little better?
That's a lot better.
Okay, good deal. All right. As I was introducing Jennifer Morgan here to my left with the Office of State Public Defender. Right here to my right is a longtime friend, Miss Allison McMahon, I think since law school, right? And with a partner at Foreman, Watkins, and Kreutz, and also has been through the foster care system as an adoptive parent. I also have the Honorable Crystal Wise Martin, who said she's going to be on Zoom. She's on our committee. She gets to be the nice judge. I get to be the mean one. But I hope she doesn't think that being on Zoom keeps her from speaking. Vicki Lowry, too, you're supposed to be down here. I'm going to be calling on you as well. So we have Commissioner Andrea Sanders and Vicki Lowry, both with Child Protection Services. And you can see just that team of ladies right there could just run the state if they had to. So it's been an honor to work with them, and I just wanted to recognize them. I also want to thank Justice Beam and Judge Hudson, who kind of got our ball rolling with, they sent a memo that they had worked on beforehand that kind of gave us some guidelines here. So thank you for that. That was a big help there. So I'm just going to kind of dive in, and I know Justice Beam kind of took it by the horns last time, but I've got a team approach up here, so I'm going to be, hopefully they'll, especially as to issues 2, 3, and 4, where those were mostly regarding definitions, and we have discussed those and sent some language around, but we've talked a lot about the first consideration, which, if you'll see from the handout, is to perform a comprehensive review and draft any necessary proposed revision of adoption statutes. It says adoption statutes, but we kind of took that to mean termination of parental rights statutes as well, and so we've taken a good look at those. So these considerations are listed. They're not necessarily in order of our importance. They're just kind of in the order we took them up. So the first one was regarding 93-17-3, that chancery courts have exclusive jurisdiction over adoptions. There was an effort in the legislature last year to amend the statute to let county court judges or youth court judges finalize adoptions and consider TPR, with the thinking that if one judge or one GAL stayed with the child through the whole proceeding, that may streamline the process. And there was some objection to that. I feel sure chancellors object to that, because, as you know, adoptions are about the only happy thing that we do sometimes. But anyway, it was unsuccessful. So our subcommittee, we're exploring ways to leave adoptions in Chancery Court so as not to run afoul of the state constitution, but also streamlining the cases to finality. And I understand that Commissioner Sanders in our first meeting, and Vicki can verify this, but she's kind of dispelled the myth that there's a big holdup with adoptions in Chancery courts. There's not a holdup with adoptions in Chancery Court. They're not languishing there, and I know that from personal experience, if it's a CPS adoption where the rights have been terminated already and you file it today, you can get it in front of me this afternoon. I'll put on the robe and we'll take pictures and do all that stuff. And I know there may be issues in different parts of the state where that's not the case, but we're trying to look at ways to make sure that moves along without removing it from the Chancery Court. We discussed waiving the filing fee for adoption. In other words, after the termination of parental rights is done in one court, you don't have to refile as an adoption with a new fee. But we didn't want to get crossways with the Chancery clerks over that. And I believe, as Vicki pointed out, that they usually pay those filing fees anyway, so that may not be an issue. But also setting a time deadline for the Chancery courts to hear the adoption matter. As I'll discuss in a minute, there was one put in place last year for TPR cases, and maybe that might work for adoption cases where CPS is involved. Maybe not necessarily for private adoptions, but for CPS-related adoptions. Justice Beam and I talked ahead of time, but this meeting earlier, and she said there may be a way that we can get MEC to give some accountability there to make sure that adoptions in Chancery districts where they're not moving as fast as maybe they could, where we could get some accountability on TPR and adoption moving a little bit to the front of the line from some of the other cases. So we're looking at that. That's still up for discussion in our group. Was there, before I move on to the second one, was anything anybody on the team wanted to say, or were there any questions about that?
I had one question for the suggestion about setting a time deadline for Chancery courts to hear the adoption matter. Did you have any recommendation, or was there any discussion about what that time frame might be?
Under I believe it's the third consideration, that there's a 120-day deadline for TPR that we're going to recommend moving back to 90. So we're kind of thinking somewhere in that range. I believe we didn't get a concrete definition, but we were thinking similar to what was just put in place for the TPR statute. All right. Anything else? Yes,
I do.
Wiggins.
What's the rationale for, as y'all put it, keeping it in Chancery Court? Because as you point out, during the legislative session last year and through recommendations from CPS, it was to streamline. And so if you're dealing with two court systems, two judges, maybe even three judges, I just don't see how that's going to be fast. So what's the rationale for doing that?
Well, we looked at that, and we think that if the adoptions stay in Chancery Court, it will be fast, especially with these deadlines. And I'm not sure what the opposition was to that bill last year, if it came from people who wanted to keep it in Chancery Court, or if it was something totally unrelated. And there's some argument that, and I printed out the constitutional provision, it doesn't use the word adoption, but it does say minors business and things that like that are supposed to be in Chancery Court. So we believe we can fix the speed problem if there is one. I think CPS takes a position there's not really one in Chancery Court, but if there is, we think we can address it.
Well, but if I understand, I mean, part of it is a territorial dispute, right, between youth court and Chancery Court.
I'm not sure.
Y'all didn't find that? Okay.
Vicki, did you? I don't know if the commissioner may have had a position on that. I don't know. No.
I will say, from the House perspective, when it was discussed in the House and I brought the bill up on the floor, I had a lot of colleagues in the House who raised some concern about moving it from Chancery courts. And when we got for a little bit further on in conference, and I would bring up some Judiciary A bills, I had one or two members who asked me during the floor debate, or it was just off the floor as we were passing each other in halls. Hey, what's the status of moving adoptions from the Chancery courts? And everyone, out of the colleagues who came to talk to me about it, all of them were opposed to it. And they felt that their Chancery court was doing an outstanding job and that it just needed, the adoptions needed to be left with the chancellors.
Right, and our committee kind of comes at it from the position of, you know, I said that we as chancellors like the adoptions. I get that, but we're also going to do what's best for the children. And if there's a wide way of thinking that this will make it faster, if there's another state that does it better, we're open to that. We hate to lose our adoptions, but we approached it as a committee knowing that there was opposition. Didn't know what that was, but we're just hoping to, I mean, we're not trying to, we as a subcommittee are not recommending removing it away from Chancery Court. We're assuming that there will be opposition from wherever that comes from, and we're trying to find ways to streamline it while leaving it in Chancery Court. Okay.
I have something that's a break.
Oh, you're recognized.
Okay, so I think all along, as I have understood, the concern, at least from the youth court's perspective, is not so much a territorial issue as it is the issue that you have a judge that follows a family and a child or group of children for sometimes 2-3 years, and then at the very end of it, the case goes before a judge who doesn't know anything at all about the family or the child. They have a report that they're reviewing. And the concern, as I have understood it, is simply that, is that it's not a good idea. You know, the argument is you want to keep a guardian ad litem on it, streamline the same guardian ad litem all the way through it. I understand that argument. But turning the case over for final permanency when you have a judge who for 2 or 3 years has been making the call about the most appropriate and least restrictive placement for a child during that period of time the child's in CPS custody, and then switching it to a new judge that has no history other than what's in the paperwork. They haven't seen this family before they come into court. I think that's where the concern is coming from the youth court side of things. And not to mention that I believe there's an avenue whereby the Attorney General could file the petition to terminate parental rights with the youth court and have it be a joint petition to file both the termination of parental rights action as well as the adoption action, which would streamline it even more. And so I think that's the argument that I'm hearing. The question, I guess, that I had is, did that come up in your discussions when you made, the conclusion to make this recommendation to leave adoption to change?
Well, first of all, that's not part of our recommendation. We're just going under the assumption that it's not going to be successful that we take adoptions away from Chancery. That's totally up to, I don't think that's necessarily our recommendation. We were just looking at ways to streamline the process, assuming it would stay in Chancery. So, but we'll certainly discuss. I don't know that that's to our subcommittee to remove adoptions from a court. I don't know that we can recommend that, but the senator and the representative may know better, but no, we're going on the assumption that they're for now staying in Chancery, because quite frankly, I don't know that you can get past that opposition.
Well, if I may weigh in, I think you're right about your subcommittee, but I think what Judge Dickinson is talking about is hitting on the issues that came up. And what different folks have heard is, like Judge Dickinson saying, for 3 years they're doing it, then all of a sudden you're in Chancery Court to terminate. And, chancellors are busy folks, and you got that. And it seemed, what we were hearing, or what was hearing on the Senate side, was that it causes delays. You have to reinvent the wheel, which is the reason why the bill past session, I guess, came about that way. So I think you're right. I think whether that stays in Chancery or youth court has it, that's a legislative decision. But I think that's the issue that this task force, and I'm speaking from the Senate side, was put together to try to address that. Because that was the problem that we were hearing was you have to, after 3 years in youth court, then all of a sudden you go to another jurisdiction and they're not familiar with the case, and it's new parties and all of that, and that's causing, or at least that's what we were hearing, was causing issues.
Okay. And we have absolutely discussed that. In fact, it goes hand in hand with, it's either our third or fourth consideration that I get to, but
Okay.
we're basically going to recommend that an agency attorney drives the whole process from the shelter hearing all the way up through the adoption. And that's
So you have one, I'm sorry, we're probably jumping ahead. So you have one person who's familiar with the case.
right, that drives it from start to finish. So,
Okay.
and
I would just like to say, I think based on what the subcommittee has presented so far with the first consideration, that, in my opinion, Judge Kilgore and his team are right on task. So we took the objectives for performance and what we were supposed to do directly from the bill. So the Senate bill does specifically say this: perform a comprehensive review and draft any necessary proposed revision of adoption statutes. I do know in the Path to Permanency bill, we also had some other bills this particular session that dealt with youth court and when youth court was going to hear certain matters, when chancery courts were going to hear certain matters. I think that's a start. However, based on just what the objective was, perform a comprehensive review overall, I think you did that. If we need to look at some other issues that are under that goal, then I think that would probably be in order if the task force determines that that's necessary.
thank you. And we will certainly continue looking at that as well. Thank you. All right, the second consideration, this one may get a little controversial too, because it may appear that we're trying to slow the gears down, but we'll explain. But it's been recommended from outside counsel to CPS that there be a revision that regarding written voluntary releases of paternity, that might help expedite. In other words, one parent can just voluntarily release. Right now, the statute says that the court may accept that written voluntary release, and the argument was made that might add an additional time barrier to permanency for the child, but unnecessarily gives the parent more time to rescind their otherwise valid release. And it's also been argued that if it's statutorily compliant, it should be accepted by the court. So take the word may out and put shall. The court shall accept that. But when people sign those, a lot of times, they're not just relinquishing their parental rights, they're relinquishing parental responsibilities. They may not want to step into the role as mom or dad, but they should still have the responsibility for that. So we want to leave the phrase may accept in there just so people are not escaping the responsibility. If there's no father to step in or mother, you're just letting this one parent off scot-free for 21 years with no responsibility. So, and in some cases it is best to accept the written voluntary release, but not always. So go ahead and come at me with that. No, I'm kidding. Any questions or thoughts on that?
Judge Kilgore,
Yes, ma'am.
I would just say your point is well taken. You know, sometimes when kids have behavioral problems, they can just drop the kids off at the state and their responsibility ends.
Right.
So it's not just child support. Parents must be responsible for their kids. It's in unique and rare circumstances that the state is to step in. Right.
And I see these sometimes, and sometimes it's the mother's in agreement, like, yes, just let him sign, get him out of here. And I asked him, I said, he's not visiting, or she, I've seen it both ways. He's not visiting, he's not bothering you, he's not doing anything, but he's paying $150 in child support. So how's it best that adds up over 20 years. How is it best for that child? He's not bothering y'all, but you're giving up thousands of dollars over the course of this child's life in child support, and sometimes they can convince me that he needs to go on or she needs to go home, but sometimes they need to be on the hook. Okay. All right. Anything else on that one?
Are there any additional questions? I don't see any.
Okay, thank you. Third consideration is a new provision in the statute, and 93-17-3 was, I believe, added this past session, and I'll just read it. Once the petition for termination of parental rights is filed with the court of competent jurisdiction, the court shall hold a hearing on the petition within 120 calendar days of the date of the petition is filed. For purposes of this section, the 120 calendar day time period will commence when perfected service is made on the parents. So two things here. That one, it's a little bit, it seems contradictory because it says the 120 days shall start the day the petition's filed, and then the next sentence says the 120 days starts when perfected service is made on the parent. So I think that's what they intended, or what was intended, but it might want to be cleared up before Justice Beeman and them have to clear it up over across the street. But we also thought that this would need to be moved to the TPR chapter. It's right now that's in the adoption chapter, and we looked at the Arkansas statutes, as you'll hear in the next section. We looked at Arkansas has a really good statutory scheme that Commissioner Sanders and CPS and the Office of Public Defender, they really like how things are done over there. So we've really carefully looked at that. But they have, rather than 120 days, theirs is 90 days. And we thought that we didn't see any reason why ours couldn't be shortened to 90 days. There are some exceptions in there. It can be extended for an additional time period if the president's declared a national emergency. I skipped one. The Supreme Court orders the suspension of in-court proceedings. And then back down after the president's national emergency if the governor declares one. And we thought about adding another provision that a third extraordinary circumstance is if the best interest of the child is served and the chancellor makes specific findings of that. There may be circumstances where you just can't do it within the 90 days. So any input or thoughts on that?
Any questions, comments?
Just to know, on the cases where the kids are in CPS custody and there's a full-time county court judge, the county court judge is the one that hears the TPR. And so in that last, I like the idea of best interest of the child being served as an extraordinary circumstance. But it may, instead of just having the chance in there, because some people judges didn't have TPRs, it might just be the court.
You're right, and I see the statute in place now says the court of competent jurisdiction, so we can just replace that. You're right about that. Court of competent jurisdiction.
That's a good change.
Okay.
I like that.
Thank you. All right.
Mr. Gilmore?
Yes.
I did have a comment that really overlaps the first consideration and the third too, and that was just my observation that it seems like what I have observed is a lot of the delays occur from our referee reports, where the referee court makes a recommendation that the case be referred to chancery for TPR, and then there's a long delay between the time that the referee judge makes that recommendation and the TPR petition actually gets filed. And, again, I think what I heard is if there's an agency lawyer that's assigned to the case from the beginning that follows the case, then that may alleviate that problem even in our referee courts if they can go ahead and start the wheels turning as soon as the youth court referee makes that recommendation that it be referred for TPR. So that to me, that's a place where a lot of the delay is occurring, not in our county courts that are usually very good about moving those forward.
I agree with you. I agree with that. Thank you. And that moves us to the fourth consideration. There's not a lot written about it here, but it has taken up a lot of our discussion. And And Commissioner Sanders has some great thoughts about this, and I know Vicki may be ready to share with that, but we recommend the one agency attorney drives the case from start to finish rather than the prosecutorial model that we have now. We discussed whether that should attach once the permanency plan becomes TPR or adoption, and ultimately decided it's best if it starts at the shelter hearing when the plan is still reunification. And if reunification is what happens, that's great, case closed. But if it goes all the way through TPR and adoption, it would be one attorney that would see the case through to final resolution. It works. They've studied it there at DHS, and it works in states that use that. And Commissioner Sanders reports that CPS is able to draw down federal matching funds and should be able to provide some state funds, but the funds would not necessarily cover the entire cost of attorney representation. But she felt that the legislature would work with us on that. So anything to add to that, Vicki? Y'all's experience with that?
Commissioner Sanders has mentioned in other meetings that just something for us to all consider. There are lots of reasons why we don't want children to stay in state custody any longer than absolutely necessary. One of those considerations, perhaps not the most important, but one that the state may want to consider, is that the average cost of having a child in state care is $40,000 a year. So anything that allows us to get children to legal permanency faster in a way helps pay for itself. The savings could be used to pay some of those attorneys' salaries, and I think we would get a much better result for the children and families as well.
I am 120% in agreement with this recommendation. Absolutely, and I've had many conversations with Commissioner Sanders and Vicki about the difference that it makes when you have a lawyer representing CPS from the very beginning, from the moment the child is taken into custody. It has a dramatic effect on the case, not just the case and the best outcome for the child, but it also has a dramatic effect on the quality of the testimony that comes in, because you have a lawyer that's there who can guide the CPS worker and correct the CPS worker for years. So this is a wonderful recommendation.
I have a question. So this sounds like you indicated, Judge, this may be the answer to a lot of this. You say this agency model works better than a prosecutorial model in states where this is utilized. Do y'all have an example of states that have done it this way? And if so, can you kind of give a little bit of a background?
Yes, there are multiple states that do it, and they do it in a variety of ways, but one good example that I think Mississippi could look to is Arkansas. They have what's called the agency representation model. And when you think about it, the prosecutorial model may make a lot of sense in delinquency cases, but we're not really prosecuting anyone in dependency cases. We're talking about abused and neglected children. And oftentimes the focus, as I've heard Judge Dickinson say on multiple occasions, we are trying to get services to that family, to that child. We're going about it in an entirely different way than we would if we were prosecuting a case. And so having an opportunity to have an attorney can help facilitate that and pull all these stakeholders together, I think can make a big difference.
So logistically, with this proposal, would it be an attorney that's employed by CPS and representing CPS?
I think it could be done a couple of ways. Currently, right now, attorneys with the Attorney General's office are representing the agency in termination of parental rights litigation, and then we have agency attorneys who are handling other aspects of the litigation. We jokingly say that their small army and our small army together are still not enough lawyers for abused and neglected children. So I think it could be configured a variety of ways. It could, in some states we see that it's lawyers with the AG's office that reside with the agency. I mean, they're technically assistant attorney generals, but they're housed with the agency and work with them on a daily basis. In other states, you see their in-house agency lawyers doing it. I really think the state has a lot of options to consider, lots of models out there. But regardless of how we label it or even how it's funded, I think if we could get to that one attorney per case from the beginning, attaching at shelter like Judge Kilgore mentioned, I think somebody would be driving that child through what is a labyrinth of legal processes.
Correct me if I'm wrong, but the Attorney General's attorney who's involved in these, they don't get involved until the TPR process.
That's correct.
So
Senator.
to like Judge Dickinson's point, it can be 3 years and then the Attorney General gets into it.
Yes.
And then we have the issues we've been talking about.
That's right.
So what, I guess what you're saying, or what the recommendation is from day one, and then you have that consistency, which conceivably could free up Attorney General folks.
That's right. And one thing that we do see with some frequency, unfortunately, is before there's an agency attorney involved, oftentimes there is some problem with due process. And if that happens before the Attorney General gets involved at the TPR stage, then that, unfortunately, that child may start over in the legal process. And so, in addition to moving children to permanency faster, I think we would be ensuring that due process is being taken care of from the beginning, and we don't end up having to start over cases because of procedural or substantive due process issues that occurred before an agency attorney was involved.
Last question. So if you're king for a day and CPS says, hey, you know, this is how many of these attorneys we need to handle throughout the state, what are we talking about?
Well, in an ideal world, you'd have one for every county or one for every court. So if we did have some regional courts, it would work, I think, to have one agency attorney per regional county court or per chancery district or however it's structured. Right now, one of the challenges with our small army and the Attorney General's small army is that many of the courts have youth court every Tuesday and Wednesday. So we could have a lawyer in Hattiesburg to cover Forest County, but they can't cover Jones County too because the courts meet simultaneously. I mean, it's a scheduling issue as much as a logistical issue. Not to say that some of those things couldn't be addressed if we all come together, but right now, those are some of the challenges we have about getting an attorney in every courtroom soon enough.
So you said that you would need an attorney ideally for every county, all 82?
Well, if there were 82 youth courts, if there are fewer youth courts, then I think we could have fewer agency attorneys and cover it. It's the simultaneous court proceedings that I think make it a particular challenge. And there may be a need for additional attorneys in what we call the high-volume counties where they routinely have triple digits in terms of number of children in care. So it may be that, like Judge Dickinson in Harrison County, it may take more than one lawyer to cover that. But in some other counties, we have far fewer numbers. So please don't hold me to any of the numbers today. Math is not my strong suit. Senator Wiggins knows that. But right now, we know 18 is not enough. I'll say that.
So do you have enough attorneys now to do it?
No, Representative Cockerham, not even close. I joke that I wish I could add water and they multiply like gremlins, but no, we don't have enough.
Do you have any idea of what the price tag would be and if you'd need additional pins? It sounds like you probably would if this was pursued.
I think we could put those numbers together, and the good news is there's Title IV funding available for some of that. And again, I do think that the savings to the state if we move children to permanency faster would help offset those salaries.
And can I add to that?
Definitely, we want to move children through the process a lot faster. It's just so that Chairman Wiggins and I could have some idea. If we have colleagues asking us, well, this is what it looks like. These are what the details are.
Ma'am?
One other question. Approximately how many TPR cases do you have a year?
We have approximately 3,700 children in custody at any given time. At the other end of that spectrum, about 600 to 650 children become legally free and available for adoption every year. The number of TPRs can vary. It's always going to be less than 3,700 and more than 650. So, a conservative estimate is probably we're running 1,200 pending cases at any given time.
Madam Chairman, may I address your question about the funding on this?
Sure.
And I'm not trying to steal Jennifer's thunder here, but I have a memo. The Public Defender's Office has also looked into this and put the pen to paper, and I have their memo here. I believe they've submitted it to Judge Pierce's team, but we got a copy as well. But it said, as Vicki noted, the child in custody costs between $35,000 and $40,000 per year. So using the low estimation, that's $2,917 per month per child. So if a parent, if this attorney or a parent defender, which we'll talk about in a moment, can speed up, reduce the time in care for just 1 month per child, of the 3,719 children in custody, it would be a savings of $10.8 million. If they can reduce the time that each child is in custody by 1 month, that saves over $10 million. So.
Well, and I'm glad you gave us those figures. I agree. I think that, there's no doubt that there would be substantial savings, and the benefit to the child, what's always in the best interest of the child is always the most important. So there's no way we can compare what's going on with the child to the monetary savings, although that's important. It's just that if this is a recommendation that the task force is going to recommend to the legislature, it would be helpful to have those figures.
Sorry. We also get, I don't think that we're getting the federal drawdown match, those lawyers right now. If we could make sure that in our presentation, we're clear on what monies are available in state funds today versus what money we could draw down, because my math is...
We're unable to hear. You need to turn your microphone on.
I don't think so.
I'm sorry, I didn't know it wasn't on. Whoop, there it is. Okay. I was just asking about drawdown for funds, for matching funds for attorneys, and we're talking about children's attorneys, and right now the AG's attorneys as well as your attorneys, we're not drawing down, and that's what match would that be?
It comes at a 50-50 after the current penetration rate is applied, so it's a convoluted formula right there. And Judge Pierce's Subcommittee 3 is one of that 4E drawdown is one of the ones, one of the things they're specifically looking at, and we're looking into it. But we can certainly add that as part of this this estimate.
Well, I think it's much more feasible when we start talking about that there are federal matching funds available.
Absolutely.
And I think that's a very valid point and a very important point, Justice Beam, is that when you take all of this into consideration, there are federal drawdowns, and then whatever the balance is, or whatever we need to make sure that we appropriate from the state, if this is something that we're going to pursue as a task force in our recommendations, that we have all of that information available.
I have a question. One thing I see a lot is foster parents don't understand the legal proceedings that they're working through, and they may get an order and it's not at all what they thought they were about. Allison probably knows some of the same stories I know. I see her getting the microphone ready. Social workers are often left to explain to foster parents what's going on, and they're often not comfortable doing that, so they don't say anything, or they say something that's wrong, and they're just not trained in that. And so this lawyer, would they be free to communicate with the foster parents to help explain that and bridge that gap? Because I think that's a lot of what gets caught up with the timeline. This foster parent gets some order and they're going, that's not what we wanted. That's not what we thought we were about to get, and so could this person facilitate that a little bit?
That's not something that we as a committee specifically discussed, but I think that is a great point, because many times the parents in the foster system are told, you don't have a representative and you're not a party, and they're not told anything about the timeline in the case or what the plan is. I know we didn't, in our case, didn't see the plan. We couldn't see the plan for months, so we didn't even know what the plan was for the children. And so I think that's, to your point, Lindsay, I think that's definitely something that we as a committee should note and make sure is communicated if this is presented to the legislature. And I will just say that I cannot emphasize or overstate the importance of having a representative of CPS in the courtroom beginning at the shelter hearing. I think we would all be amazed at how this could radically change the timeline in the system. By the time that the case gets to TPR, as Vicki has already alluded to and specifically stated, there are many times problems, and when she said due process, many times there are problems, it's service of process issues. Like, they literally didn't serve a parent correctly 3 years before, 4 years before. I had a case that was 8 years previously that a parent hadn't been correctly served. So these are very, very minor changes, can make major, major differences with people's lives. And so to the extent that this is brought to the legislature, you need an advocate. I'm happy to go give my perspective. This needs to be done. This needs to be done, and it needs to be done to protect every person in that room. The child, first and foremost, the biological parents, they need this. The parents need this additional support for resources from the agency, because many times the social workers who are totally overworked and too much is expected of them, they're expected not to only present the case from a legal standpoint, they're not lawyers, and they're also then expected to get all the resources to the parent. There's no way we expect them to be superhuman, and they just can't do all that's expected of them. And having a legal representative in the room from the agency that knows from a legal standpoint what has to be done to get the case from A to B, and then also freeing the social worker up to do their job, to provide the resources to the parent. I mean, when a parent is asking for a resource, the response from the social worker can't be, well, I don't have time to come out to your house and pick you up and take you to whatever therapy appointment or mental health appointment that you need. That can't be our response. And that is oftentimes the response because the social worker simply doesn't have time. So we need to let the social workers do their job as social workers and the lawyers do their job as a lawyer. We can't keep expecting the social workers to do what they're doing. So I will get off my soapbox now, but I really cannot overstate the importance of getting these legal representatives from the agency, the experts, and the attorneys in the room from the beginning.
Sure. I know we're talking about the foster parents and the biological parents. Many of these kids now have standing in court. All of them have standing in court. And what we've run into is the turnaround's too quick from when it's on the docket to coordinate getting everybody there. So having this person being able within the agency will actually allow the youth to be more represented as well. Because that's the same logistics that you're talking about are what are keeping the youth from being in court and having a voice in their cases. And so this could additionally help with that.
Any additional comments or questions? If not, Justice Kilgore, I'm going to turn it back to you.
All right.
I did have something to note in the comment about the foster parent receiving the orders. The current disclosure statute does not allow for that. And so, I think Senator Williams may have had a case where this came up down in Harrison County. But as the statute is currently written, the way it's worded, youth court judges are not supposed to be disclosing copies of the court orders to foster parents. They're not considered custodians. The custodians are Mississippi Department of Child Protection Services. Just want to make that point.
For the record, Judge Dickinson followed the law.
Can I make a comment on that?
And Judge Dickinson, I wanted to mention that we now have the foster parent bill of rights. It just went into effect July 1. And my first new requirements that the foster parents be advised about all the proceedings and allowed to be heard on issues. How does that interplay with the confidentiality statutes as they're currently written? And thirdly, I think again, the agency rep, the agency attorney from the beginning is going to be a great answer to a lot of these issues, because there will be an agency lawyer who can explain the legal issues to the foster parents, and it takes the burden off the caseworker to when they're put in the middle of providing a legal advice about what's going on when they may not even know what the real standard is. So, but I think that's going to be another issue that has to be looked at, is whether there needs to be some change to the confidentiality statutes because of the Foster Parent Bill of Rights.
This is going to be a very unpopular opinion in this room, but I think it's a slippery slope when the parents and the youth have the least representation in the room and they have the least advocacy for them. I always, as a former foster kid, as someone working with foster parents, I always make sure they know that a foster care is not where you come to adopt. Foster care is where you come to help a family get reunited. And it's a slippery slope of, I absolutely love foster parents. My foster parents are my parents. But the goal should always be those foster parents should be trying to help a family get back together. And so to me, it's just a slippery slope of people who want children, and they see the foster care system as a place to adopt easy. And it's great. I want every child to have a home, but I don't want it to undermine the rights of the biological parents to be reunited with their child when that should still be the case. So like I said, probably unpopular, but making sure that those foster parents understand the goal until there's a TPR is reunification. And
you mentioned the natural parents being the most unrepresented people in the room, and that gets us to our fifth consideration. So that's a nice segue. And anything else on the fourth one, though? Okay, the fifth consideration is regarding parent representatives. Again, we turn to Arkansas for this, and I know in the TPR phase of this that I had one this morning where it was a TPR case with the Attorney General's office, CPS, and the father had an appointed attorney. He came in and requested one after he was served, and the way I understand, and I think most chancellors understand, the U.S. Supreme Court and our Supreme Court is saying that they need an appointed attorney, and I've done that, but it's only that phase. So we're looking at parent representatives similar to what Arkansas has, and they have a great statute that Jennifer had attached to her thoughts, and she'll discuss this in a moment, and also their Senate bill. I can email that out because it's really good. I wish I had it ahead of time, but we were working on this yesterday afternoon as well. So, but CPS can fund this as a significant agency funds will be saved by reducing, again, like the parent representative, by the length of time that the children are in state custody. The rest of that, it talks about the juvenile court representation fund that Arkansas has. We can look at that. That's just to show an option where basically some parents who can't afford attorneys are ordered to pay some, and this goes into a fund and may help indigent parents. But if there are not enough funds in there, then the state funds are exhausted, the court may order the county to provide indigent counsel for indigency. But this would also, my understanding is that we're looking, and we're still discussing this too, but we like the Arkansas model, but it was something that would attach in the early phases of the dependency proceedings as well. Is that your understanding? And the State Office of Public Defender feels very strongly about this particular incident, so I'll let Jennifer comment on that.
See, I was just waiting for my soapbox. So many great things have been said. I like the agency model. Just going to put that out there. And it's because when we start getting parent attorneys,
now that CPS is a party, we're starting to run into the issue of ethically, can we talk to that represented party in a youth court case without an attorney there? That's something that CPS and I've talked about, and like, well, we don't have an attorney there, but we see what you're talking about. So we would love to have that point of contact. If you're an attorney or you worked with an attorney, you know, a lot of things can be resolved outside of court, and we can streamline stuff and we can get things done. As Judge Kilgore said, it'd be a cost savings for parent attorneys. Arkansas has mandated parent attorneys to be appointed to indigent custodial parents at the emergency removal hearing, and then mandates attorneys for all parents when we get to TPR, and it's discretionary for non-custodial parents during the CPS phase of a case. We thought that was a great cost savings while also protecting the rights. And it goes back to that due process right of most of the appeals that I'm reviewing right now. There were service of process issues, or there was some issue that was back at the youth court that if we had done that at the beginning, if they had had an attorney at that beginning, I wouldn't be writing a brief on it 3 years later. And 9 times out of 10, I lose on appeal, but I'm still arguing that because that parent had that right to be properly served. And if we could just cure that from day one, it's so much faster. These kids could have already been adopted if the termination held, and it's just such a cost savings. I also wanted to bring up what else was discussed about social workers being social workers and attorneys being attorneys. The gold standard for parent representation is to have a parent attorney, a parent social worker, and or peer support, someone who's been through the CPS welfare system and understands it and can take that parent and say, I know what you're going through, let me help you. And it goes back to CPS, their number one has to be the child. So if they're taking a child to a doctor's appointment, they can't help that parent get visitation. But that's where the support staff or an attorney can help. We have estimated that $3.3 million is about what we would need to fully implement it on this gold standard throughout the state. And that's where the numbers of a savings of $10 million really come into play, because that's just 1 month. All the studies that have been done on this actually says it is a savings of average of 4 months have an IDT, an interdisciplinary team for a parent. So if it's 10 million for 1 month, four times that is what we're looking at a cost reduction for CPS. So we don't see any reason not to have a parent attorney and not to have that gold standard, because Mississippi families deserve that. I think our children deserve that. And if that's keeping that kid out of custody for 1 month or 4 months, then that's what needs to be done. And it's not just on reunifications. It's getting to that TPR and adoption faster, of talking to that parent. You know, if we need to voluntary surrenders, I absolutely believe they should have that attorney to go over it with them. And that's just not happening in a lot of places. They're told, you can talk to an attorney about it, but we're not going to give you one. But that is something that is life-changing, that is severing, that is the death penalty of their family. And they should have an attorney to go over that paperwork with them. I'm going to get off my soapbox now.
I would 120% agree with Jennifer on this issue. I mean, I talked about it many times. You can talk about taking away all the assets that I have. When you start talking about taking away my kids, that's a completely different fight. And these parents have to have representation. I fully believe we need to fully fund the parent program in the state of Mississippi. It needs to come into play at the very beginning, just like the CPS order. We need all these people on the front end. That's my 2 cents. And we do it in Harrison County, and it works.
If I could just tell how we've come a long way, baby, over the last 12 years. This idea was birthed in the Children's Justice Commission about 12 years ago. Tom Broom, who passed away this year, he really pushed this a lot, as well as Judge Hudson. Right now, we have about 75% of our foster care children, the population, as I understand, served by parent representation. It's not in all of the smaller counties, but we have tackled many of the larger counties to reduce the number of kids in custody. And that cost is borne by the state as well as by the county. The way we sold it is that the county would match those funds. And I think that that is one reason why over the last 8 or 9 years we have had a substantial number of kids that have been reduced from our foster care rolls. I can remember when our numbers were 7,500 or more in foster care, and when we look at it now in 37, that's children that are not on the are not being traumatized, which we know removal is part of is traumatic for them. So we've come a long way, and we certainly won't. We've seen the investment that it has paid off substantially. And I'm not saying it's all parent rep. It is educating all of the court system on trauma and removal and so many other things. But having an advocate in that courtroom with a parent is very helpful.
I think it's a good recommendation. I know that Andre, towards the beginning of the session, he had come over for budget hearings and he talked about this particular recommendation, and then towards the end of the session during conferencing it came up again. And so I think it would be extremely helpful to have the parent representation. I do think too, I know that this particular session, we said that the GALs, the guardian ad litems, they could represent the child as well. And so I think that's probably when we were conferencing both the House and the Senate, that's when I got the renewed request, Jennifer, from y'all's office to say, hey, will y'all include this? Will you consider including this? So there has been some discussion about it. I think that it's a good idea. Chairman Wiggins and I were just up here a few minutes ago wondering if we did include any money now for parent representation, Justice Beam, so I'm glad you highlighted that. But I like this particular recommendation a lot.
One other point I would make is there are drawdown funds available for this. Have we started that with the Public Defender's Office?
We have an agreement in place with CPS. We've got the forms to do it, and we're actually meeting next week to talk more about how to maximize it. But we are ready as soon as CPS says send us the report.
Great.
Any other questions, comments? Seeing none?
Thank you, Madam Chairman. These next two, they're kind of simple. I'll breeze through them, but they're the sixth consideration is Arkansas has a provision regarding streamlined adoptions, and that's where a family who has previously adopted a child and is interested in adopting another one, they don't have to jump through all of the hoops that you would when you're a first-time adopting parent. And Commissioner Sanders and Vicki Lowry were going to look at see if that could be done administratively rather than through the statute, but I did want to mention that we were looking at that as well. I'm not even sure how often that occurs, but it seemed like a good thing to do. Any thoughts on that? Okay.
I personally think it'd be great. I have a child right now who's in foster care that 85 days ago was TPR, was just still waiting on the adoption to go through. So if there was a streamlined process, amen to that.
Good. Okay.
We agree. We have some policies in place right now that require less than a full home study and less than some other things. If a second or third child is being adopted within a certain time frame, but we're looking for some other opportunities to streamline as well. We'll circle back with more information about that.
Anything else on that one? Okay, the seventh consideration, this is kind of random, but I just wanted to put it out here. It's all, I found it when I was looking through the Arkansas statutes that say you have a mom and a dad with two small children. One of the parents dies say the dad passes away, and then the mom remarries, well, her new husband can adopt those two children without notice to anyone, which doesn't seem really right. This has nothing to do with CPS or anything like that. This is just something to think about. But they have a statute that requires you to give notice to the parents or a family member of the dead parent before you can just proceed with an adoption. So that's a little off the beaten path, but worth thinking about. So, any feedback on that? All right. Our next three, that's all on question one, which was looking at the statutes. The next one, it's kind of hard to, we're kind of going back and forth with its verbiage, its definitions for certain terms that are already in the statute.
Excuse me.
Yes.
I don't think.
There's no handout for that.
Okay.
We're still going back and forth with the language on that, so we'll just kind of discuss it, and we'll once we pinpoint some recommended language on these, we'll get that to you. But I'll take them one at a time. That our first one is review the use of reasonable efforts and diligent search in the CPS statutes and determine whether a uniform definition is needed for each term, and then to draft the language. So currently, reasonable efforts are in Mississippi Code 4321-105 GG. It says as reasonable care and due diligence by, and it still says Department of Human Services and the Child Protection Services or any other appropriate entity or person to use appropriate and available services to prevent the unnecessary removal of the child from the home or provide other services related to meeting the needs of the child and the parents, which is pretty vague. The Office of Public Defender has a proposed definition, and CPS has a proposed definition of reasonable efforts. I don't mind sending them out, but I didn't check with either one of them if they wanted the whole committee to send. But we can get that out if you want to look at those. And in fact, I probably have them on an email I could get out pretty soon. But it's pretty lengthy. But did you want to on yours? Or CPS? Did y'all want to comment on that? Okay.
I would like to see the definitions. I think it would be helpful if it's something that we're going to consider or think about, if maybe we could email it to the whole committee so that everybody can take a look at the proposed definitions.
Okay, be glad to do that. And I have them right here. I can probably get that this afternoon. On diligent search, it's not addressed or defined in the same extent in the statute, so a more specific definition would be helpful. The Public Defender's Office suggested adding a social media provision under diligent search, and then CPS submitted a very detailed definition of what diligent search meant, meaning it starts at the outset of the case. It must include at a minimum interviews with certain people, including the child, interviews with identified relatives, and comprehensive searches of certain databases. It's an extensive list, and I don't know if either one of you want to comment about your recommendations on diligent search, Vicki or Jennifer, but I can send that out as well if y'all are in agreement with that.
Just one comment. One concern we have about any definition for diligent search is we're going to have to keep in mind the ethical obligations for social workers when we talk about social media policy. So we'll have to balance some things there as we work toward a practical way to go forward.
And that also comes back to the diligent search. What can be released to these family members that you think you found about the child and the family situation? Because I don't know if y'all are aware of this, but people move a lot. And I'm like, I didn't grow up like that, but that's the reality of what a lot of our clients are looking at. And so if you send grandma a letter at the old address that says the child's name, birth date, all the family members, and hey, they're in CPS custody because of this, then you just told a complete stranger everything about this child's case with CPS. So there is a lot of balancing that needs to be done with it, and that's kind of one of those reasons why we're not particularly ready to say, here's what we recommend.
I would also say that's a lot of disclosure before vetting, for safety as well.
Okay. All right. Question 3 was more definitions or examples through a non-exhaustive list of what constitutes compelling and extraordinary reasons why termination of parental rights would not be in the best interest of the child. I know the Public Defender's Office has a position on that if you'd like to.
Vicki and her team actually sent out a list, and we made a few tweaks to it as far as what OSPD liked. It included things of when the child is cared for by a relative, and that relative is unwilling to participate in TPR, when a guardianship is available, when a natural parent is incarcerated but subject to be released, when a natural parent is terminally ill and unable to care for or provide for a child, the absence of a parent due to the parent's admission or commitment to any institution or health facility, or due to active service with the armed forces, and that would include things like they're actively getting treatment for substance use. If a child 12 years or older objects to the termination, these children, we're not just severing that parent's rights, we're severing that child's rights too, so that has to be considered. The child is placed in a residential treatment facility and adoption is unlikely, or if the child is likely to age out. There's no reason to terminate on a 17-year-old when almost 95% certain that child's just going to age out of custody, and then you've left them with nobody. You left them with no family ties. ICWA reasons, that's the Indian Child Welfare Act, or the agency has not provided services within the timeframes indicated. So we tried to come up with just some general situations where we needed to take that step back and go, we're not ready to terminate yet. We've got different pieces happening and we want a little bit more time, so let's look at it, and these are the reasons why we don't think termination should happen right now.
If I could piggyback on that, the youth I work with are the ones that left the system. And most of them left the system with no social supports. So the state's done with them, but they are not connected to anybody. And they have to be connected to somebody. Who do you go to for Thanksgiving? What do these things. They may not take guardianship of these kids, but anything we can do to connect them to people who will be there for them once we're done with them is paramount and huge. And so even if it means we don't terminate their parental rights because we're trying to keep that family together, knowing that they won't go back until adulthood in a non-child parent relationship, I just highly advocate, because that's what I spend 40 hours a week doing, is working with these kids who have left the system with no one to call when they have a bad day. So just putting that out there.
I want to echo on that. I don't know if it was you, but we were at the program that CPS put on, and there was a panel discussion, and there was a foster, she's in college and doing college, and that was what she said, was that she went through this and she had nobody. And I personally think that took a lot of people by surprise. And I certainly didn't kind of think about that. And so that's why this task force, I don't have a suggestion or solution, but I just raised that point because if you think about it, these kids are going through and they're making their way and they don't have anybody. Is that, was that y'all that put the panel on?
Those were some of our youth, yeah.
Okay.
And I mean, we can do with the Faith Scholarship. Well, now they aren't homeless during Thanksgiving break.
Right.
But they're sitting in a dorm room eating ramen noodles while everyone around them's gone home to family. So just those connections. And that's not an easy fix. It's not, it's human beings. So I don't know that we have a full policy issue on that, but anything to keep connections viable.
I would just point out, I did give that little girl my card and told her she's a Southern student to come have Thanksgiving with us. But I'm reminded on that same panel, we had a 19-year-old who was pregnant and also in college, and she said she was homeless, and I was concerned, and it turns out we've been doing a lot of things, thinking outside the box in this area. We now have federal vouchers that are coming down through HUD. That little girl was going to be going into one of those those apartments, and they get caseworkers that help them to get resources. So we've got a lot of positive things that are going on outside of what we're talking about today with regard to legislation.
And she's being released from the hospital today with her newborn.
I'm sorry.
I'm sorry, I wanted to follow up on the comment about the child's rights in the TPR. Now that children are considered to be parties in the youth court proceedings, I think the question that some of us have talked about is whether they should also be considered parties in the TPR proceedings. So that they would have, especially if it could be limited to children aged 12 and older, but they should be entitled to an attorney who's representing their interest in the TPR proceeding, because it is the children's right that is being terminated as well as the parent right. But that was just a thought I wanted to mention.
I'll add to that. Currently, it's not operationalized to happen. So if the guardian ad litem is looking at cases a few days out, there's no time to get input from that youth to know if that guardian ad litem is representing the youth, or if they have divergent views on what should happen, and if separate representation is needed. So if there's not a way to trigger knowing if they need separate representation, then it can't happen. So that is something that I think the next committee has some of those things on their task.
Any further comments or questions? If not, Judge Kilgore?
Okay. I'll move to question 4, and I'm glad Professor Calder is here with us on the line, because that task is draft definitions of neglect as willful or non-willful with a proposal for different courses of action depending on the type of neglect. And basically the goal there is to make sure that a parent out there doesn't lose children just because they're poor. And I know that Professor Calder and Bill Charlton with the Mississippi Judicial College were major draftsmen of a definition this about a year ago, I think, which was very good. CPS, and Vicki can clarify for me, I believe they had an issue with the word disadvantage. Was that or maybe some other language in there? And thought maybe that may lead to some unnecessary complication when it could simply say a clarification that poverty alone is not enough to constitute neglect, and that might be more beneficial. So we're still talking about that, but go ahead, Vicki, and I want to hear from Professor Calder as well.
Yes, the draft definitions are excellent. There's just, the agency had concern about one sentence that implied that services should be provided to those children, and it would appear that they could be seemingly endless, and that if we had the budget and the staff, if we were, as Senator Wiggins says, if I were king for a day, we would gladly accept that responsibility, but we have limitations. And so if we could find some way maybe to temper that one sentence, just so we don't set the agency up for failure and disappoint a lot of family and children.
So that's where we are as a committee, is kind of using that, absolutely, but trying to maybe soften that wording a little bit or change it a little bit. Anything you want to say to that, Professor Calder?
Well, I will say that we did spend a lot of time trying to find the terms that would be the least pejorative as far as trying to describe what we were to accomplish here. But, we came up with a lot of other terms besides disadvantaged, and none of those things work. But I think what you're saying is that we can certainly address the issue. I think just by using the term poverty and describing it as that circumstance. But I think maybe what we could do on the services side is just add a clause that indicates that provide the services necessary to ensure the safety and welfare of the child, or something along those lines. It's going to be your mission anyway. But that would help maybe clarify. And I'll be glad to take, I'm just multiple states that had adopted statutes similar to this, so we came up with different examples that kind of led us to where, to the definition that we settled on that most deal with our current statutes. So I'd be glad to look at that further if that would be helpful.
That would be most helpful, Professor. Thank you.
Yeah, and we thought it was a great definition for that. Just had that one concern from CPS. So thank you very much. And I know I put you on the spot, Professor, but I appreciate that input very much. We'll definitely keep talking about that.
If I could just throw the statistics out there, 1 in 4 of our kids lives in poverty. 45% of our black children live in poverty, and 1 in 5, or I think it's 22.9%, are food deprived. I say nobody should lose custody of their kids just because they're poor. And so we want to, those that have a need and through no fault of their parents, we ought to be like the Red Cross or the Salvation Army, bringing in the rescue. And my hope and prayer is that not just CPS, but all Mississippians will step up and be able to plug in and help build our families.
Okay. Anything else? All right, that's all that we have. Unless anyone else has any questions or anything else we need to consider or take under advisement, as judges like to say.
I don't see anything, so we want to thank you, Judge Kilgore, and the entire Subcommittee Number 2 for that fantastic and very substantive presentation that you made. And when you finalize your definitions, if you don't mind, will you email those proposed definitions out so we can get them to the entire subcommittee so we can consider
I'd be glad to,
those?
and I don't mind sending, I believe they've agreed, I've got 2 definitions, one from CPS and one from the public defender on each of these terms that we're kind of trying to mesh and work through. I don't mind sending that out as well in case someone has some helpful input on that.
That would be great, thank you. So now we're down to determination of future meetings, and we have one last subcommittee report that's going to be Subcommittee Number 3. And that would be Judge Pierce. And so we need a date for October.
I was looking at my calendar and I was hoping maybe we could work around the week of October the 23rd to 27th, sometime in that time frame. Are any of those dates acceptable? Or I guess the better question is, do any of those dates not work for anybody?
October the 24th doesn't work for me.
Okay.
Or the 23rd.
So the 23rd and the 24th are out.
Okay. The 26th, is there any conflict with that?
I don't have any conflict. Committee? Task
The
force?
trial conference is the 25th through the 26th. I don't know if any of the judges on here plan to go to that.
I do. It is that Wednesday, Thursday, and Friday, but I can get on by Zoom probably, so it's not a problem if that works for everyone else.
I agree. This is Crystal Watson. I do plan to go attend the conference, but I will try to get on if that's the date that's chosen.
So it's the 26th? All right, I don't hear any opposition, so we'll set it for the 26th, October the 26th at 1 o'clock in room 113. Is there any further business to come before our task force this afternoon? Seeing none, I want to thank everybody for the great attendance. Once again, fantastic participation with the questions, the comments, the concerns. A few of us were talking right before the task force meeting convened about how we really have the opportunity to submit some really substantive recommendations that will do good for the children here in the state of Mississippi. So Chairman Wiggins and I thank you. We know that you all have very, very busy schedules, and you have been committed to this from the very outset. So to everyone who's here in person or participating via Zoom, we can't thank you enough for your input and your hard work and your dedication. And if there is nothing else further to come before the task force.
Vote on the minutes, or from last?
Oh, yes, we do. Thank you, Lindsay. Has everybody had a chance to review the minutes from last month? Are there any questions about the minutes or any changes? God bless you. Seeing none, I'll entertain a motion that we accept the minutes.
So moved.
We have a motion. Is there a second? We're going to have Justice Beam to second it. All those in favor say aye.
Aye.
Are there any opposed? So those minutes are adopted. We want to thank CPS for preparing the minutes. Also want to thank Juanetta and Cassie for their input with the minutes as well, and making sure that we get it all copied and disseminated. So thank y'all so much. With that, if there's nothing else, we'll consider ourselves adjourned.
Great job.
How are you? I know. I was thinking both of y'all, you and both of me. I want to give both of y'all my card. I have I'm Jennifer Morgan. Sorry. Jennifer Morgan, OSB.
Let us out by 3.
Yeah, I tried out.